Holding us up. No, don't let it happen again.
No, we won't.
Not before we are.
Good evening, everybody. We're going to call to order tonight's Township of Bernard's Zoning Board of Adjustment. For those who are in the hallway, you can come in. There's seats along the back and along the side. The first order of business is the flag salute. So if you can stand, we'll invite you to stand. In accordance with the requirement of the open public meeting laws, notice of this special meeting of the Board of Adjustment of the Township of Bernards was posted on the bulletin board in the reception hall of the municipal building, Collier Lane, Basking Ridge, New Jersey. It was also mailed to the Bernardsville News, Whippany, New Jersey, the Courier News, Bridgewater, New Jersey, and it was also filed with the Township Clerk, all on May 25th of this year, and was mailed electronically to all those people who had requested individual notice. The following procedure has been adopted by the Bernards Township Board of Adjustment. There will be no new cases heard after 10 o'clock tonight, and there will be no new testimony heard after 10:30 tonight. Ms. Keeper, can you do the roll call for us?
Certainly.
Thank you.
Ms. Janiers,
I'm here.
Mr. Cambria,
Here.
Mr. Kraus,
Here.
Mr. Pavlovsky,
Here.
Ms. Pakhtar, Mr. Tancredi,
Here.
Ms. Herrera,
Here.
Mr. Fishinger,
Here.
Mr. Warner,
Here.
Mr. Quinn,
Here.
Mr. Schley,
Here.
and for the record, Ms. Kiefer is here. I guess Ms. Baumann and Mr. Halverson have indicated that they were unable to attend this evening, which is
Excellent. Thank you. So do we should ask for a motion to excuse those two who gave us prior notice, please?
So move.
Thank you.
Second.
Thank you.
all in favor?
Aye.
Opposed? Abstained? Thank you.
Thank you. The next order of business is the approval of minutes from our August 9th regular session meeting. They were already circulated to the board if there's any edits or comments on those. Otherwise, we will entertain a motion to approve the minutes.
Motion to approve.
Thank you, Mr. Krause.
Second.
Thank you. Ms.
Shall we?
Pop.
Someone other than board member Pakhtar, I think was absent.
August 9th, oh, I'm sorry.
August
August
I was
9th.
here last week, sorry.
Mr. Tancredi seconds it.
Alrighty. And, yeah, Ms. Pakhtar, you were recused.
Recused, yes,
So,
sorry.
all in favor?
Aye.
Opposed? Abstained? Thank you.
Thank you. The next order of business is the public hearing for 6A, the Basking Ridge Project, the Braemar Partners. Are you here tonight?
Madam Chairman, I'll recuse myself.
Thank you, Mr. Tancredi. Mr. Lair.
Good evening, Madam Chair, members of the board, members of your professional staff. I'm seeking just a one-year extension on the ability to secure a certificate of occupancy. The resolution at a particular section, I believe it was, I don't have the exact, yes, it's condition 44A on page 33, gave the applicant a 2-year obligation to secure a certificate of occupancy. They've run into some significant site constraints. They're moving along and they're pretty close, but they need just that flexibility of a 1-year extension to secure the CO. They're moving forth with due diligence and continuity of purpose, so I would ask for the 1-year extension.
Can I just ask one question?
Yes.
It is, situated between 2 residential houses in that area.
Yes.
Is there any leeway on shortening that time frame so that the construction isn't prolonged in that residential area? I'm just asking.
I think that if you wanted to go to 6 months, I could probably get it down to that, because I think they're pretty close.
Okay. I mean, I've seen the site, going back
Yeah.
and forth. Accidentally actually went in the site.
Yeah.
But see that's still under construction.
So if you
just
want to do
curious
6 months,
if
I think we could
would
live with
help
that.
The public and help,
Yeah.
if you could get that done.
Do you mind just touching on some of the reasons that it
Sure.
was, an extension is requested? What were some of the
Sure. Madam
time
Chair,
constraints?
There were quite a bit of, number of structures on the property that had to be removed, lots of regrading, lots of landscaping work, lots of, and I was here because I remember how much landscaping was involved in that application. So it has taken more time than we had imagined, but we're close. And for those reasons, I think we can say with confidence that 6 months would do it. I was just asking to just be safe than sorry.
Is 6 months
From-
reasonable, or, because I also want to make sure you have enough time.
Well, it would be 6 months from today, so that would be about 8 months from June when it expired.
About 9 months. I'm not comfortable with 6 months.
Yeah, 6 months is a
That's
short
fine.
time frame.
Move along
Things happen, I
very
know.
quickly As far as I can tell, and I don't even know if they could have done it in a year without any obstacles. It's a very big.
It's a big
Okay.
project.
Yeah, and I think, if I may, Madam Chair, because it's our bylaws, it's not by ordinance or statute that it's required. And also, we have the same 1-year period regardless of the magnitude of the project. So it probably makes sense to take into consideration the magnitude of this particular project. And correct me if I'm wrong, Counselor, but where are we here? It's a request to May 10, 2024. So I'm not good at math, someone help me, but it may not be much more than 8 or 9 months anyway. that we're
Correct.
asking you. It's 1
Yeah.
year from the expiration, which was quite a few months ago.
Yeah.
Just, yeah, I would consider the goal of making it done, I mean, completed as soon as possible so it doesn't impact the residents,
Yeah.
you know, that are living in that area. That's
Yeah.
So
No,
would
I-
you be asking for 1 year from May 10, 2023 still?
That's correct.
Okay.
Okay, thank you. Thank you. Are there other questions or comments for Mr. Lair?
If not, Madam Chair, we did send, and I apologize for sending 2 versions today, but we shortened it on the second one, so that's a good thing. So, we did send a resolution for the board in the event the extension was granted, which
Yeah.
I think would still stay, the language would stay the same.
Yeah. No, I appreciate your comments, Mr. Kraus. Personally, I'm comfortable with the date that was requested, because obviously we want to make sure they get it
Definitely.
correct in the end here, and there's a lot of landscaping work that I think we're going to opine on later tonight, or in just a little bit, so we want to make sure that they get it right as well. Any other questions or comments, or a motion to grant or deny the extension?
And we could go right to adopting the resolution.
And
as a
if we're
grant.
going to, the motion is going to be to grant the extension. There was a resolution, multiple resolutions, but the final resolution draft was also circulated earlier today that I think everyone had a chance to read and review.
Even though the wording says 1 year, the expiration of the extension is still the May 2024.
Yeah,
Cor-
it's
correct.
1 year from the time, that's right.
Exact, from the expiration of the original timeframe, yeah. Any motion?
I make a motion that we extend the permit to the May 10th, 2024 date as requested.
And are you comfortable with the resolution as drafted?
Yeah, I mean, I haven't been inside the site, but I've been there, and I see the trailers, and I see they're having visitors, and I see the landscaping is moving along, and, you know, I have no idea what the interior work is, but that usually takes a lot longer than landscaping, but I'm comfortable with it, yeah.
So we have a motion to, I guess, approve the resolution as drafted to grant the extension. Is there a second?
I'll second.
Thank you, Mr. Kraus.
Mr. Cambria?
Yes.
Mr. Kraus?
Yes.
Mr. Pavlovsky?
Yes.
Ms. Pakhtar?
Yes.
Ms. Herrera?
Yes.
Chairwoman Juniors?
Yes.
Thank you.
Have a good night.
Good
No.
night. Works for us. Okay, thank you. Next up on the agenda is.
Are we doing the landscape
Oh,
committee? 'Cause
yes, we are.
I think you'll have to stay out another minute or two for the
Yeah,
landscape.
sorry,
committee.
Mr. Tancredi, thank you. Mr. Tancredi is still recused.
Exactly.
Next up on the agenda is 7A, which is the appointment of the Landscape Committee for the same project, the Basking Ridge Project, the Braemar Partners. I think we talked about extensive landscape to help protect the residents that you already mentioned, Mr. Kraus. So are there, how many do we need, Dave? 2? 3? 3. Do we have volunteers who want to be part of that landscape committee? Mr. Kraus? Thank you. Mr. Kraus? I'll do it as well. I'm Ms. Herrera. We got 3.
I'm sorry, and who was the third? And who was the second then?
Ms. Herrera.
The chair.
I did.
Oh, all
Yeah,
right, thank
special.
you.
Yeah. Okay, thank you. Thanks, Mr. Kraus, and thanks, Ms. Herrera. Mr. Tancredi.
Yes, please.
Okay.
You could-
We'll just let the record show that Mr. Tancredi has rejoined us. Thank you, Dave. Next up on the agenda is the completeness and public hearing for Peter and Nicole Mayo, which is ZB 23012, which was carried from our last meeting, and our apology also carries from our last meeting, so sorry to make you sit here for that period of time and then bring you back today, but we did the best we could to hear it at our next moment that we could.
And if I may, Madam Chair, just to let the record reflect that we announced at the last meeting that this matter would be carried without further notice, that the notice was sufficient, timely served, and published at the time. So the board continues to have jurisdiction over this matter.
Thank you, Mr. Warner.
Thank you.
Welcome back.
Thank you. Good evening. Catherine Muller of the firm Page Muller Engineering. I'm representing the applicant, Peter Mayo, at 444 Mount Airy Road, and I'll also be testifying as a professional engineer.
And I will swear you in along with our board professionals. If all of you will raise your right hand, thank you. Do all of you swear to God or affirm, and the witness as well, the applicant, do all of you swear to God or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you all.
Thank you.
So Catherine with a C, Muller, M-U-E-L-L-E-R, a licensed professional engineer in the state of New Jersey, and my license is in good standing. I've been before this board a number of times.
Thank you. We will accept you, so.
Thank you. So I'm going to present the application. It's for steep slope variances in 3 categories. We do have the property owner here if the board has any questions for him after I give you the technical data. Let me just pull up my plans here. What folder are they in?
They're already down the bottom there.
Oh, thank you. So again, this is the application for 444 Mount Airy Road, Block 5203, Lot 18. The property contains a single-family home, and what I have up on the screen is consistent with what we submitted as part of the application. Our variance plan dated June 5th, 2023.
Okay, no need to mark as an exhibit, just refer to the sheet number, please.
Thank you. So I have sheet 1 of 1, the cover sheet up on the screen right now. As I've indicated, this is for steep slope disturbance. It's a unique lot that fronts on Mount Airy Road. And what I show on this sheet is actually from the 2004 Township topo. So this is before any disturbance was done. As I said, it's a unique piece of property. It's just a bowl that was left in the neighborhood area, and the house is at the bottom. We have about a 40-foot drop from the rear property line to the back of the house. So we delineated all the slopes from the old topo. These are pre-existing conditions. We did the slopes in the 3 categories required: 15 to under 20, 20 to 25, and 25% and greater, which is the darkest bands. So all of those are regulated either by percentage, and anything over 25%, no disturbance is allowed. So what we did is we established the conditions on site. We used the survey from when Mr. Mayo bought the property in March of 2020, the beginning of COVID and the lockdown. So what we did is we established all the pre-existing conditions, and then we did a second current survey, which I'm gonna switch to sheet 2 of 2, everything that I show on the left here are existing grades on the property. There were no grades that were significantly changed. As Mr. Mayo and his wife were having a baby and working on the inside of the house, it was in pretty far disrepair. His father-in-law started working in the yard. There were retaining walls that were replaced, new ones that were constructed around the side and in the rear of the property. Per Bernard standards, these would not be presented in front of the board. Some are over 5 feet or over 4 feet. They'll either be shortened or we'll write a certification as to the construction of them. But what was done immediate adjacent to the property would not have required a variance. We did not disturb any of the steep slopes. But then the clearing and the cleaning started in the rear yard. So again, the property was in far disrepair. And again, I have Mr. Mayo here, he can further testify to it, but there was a lot of debris in the backyard, dead animals, fallen trees, just brush in general. So they started to clean that out. There were about 8 to 10 significant trees that were removed. The species were unknown, but it wasn't heavily wooded. It's really just overgrown in the back. And then they got stopped by the town for disturbing the steep slopes. So the one thing that I want to impress to the board is that these were not created steep slopes. They did not start digging out the backyard and create this condition to then go ahead and build walls. There was a small area on the north side of the property, right where I have the cursor, like in the middle of the north side, just to the left of the house. There was a knob that was sticking out and some dirt was removed there. But directly behind the house, all of the slopes are essentially existing. They cleared out the debris, and again, about 8 to 10 trees. Some were in poor condition. There was some concerns that they were close to the house, and just being on the natural steep slopes, they seemed unstable and were cleared out. So the proposed improvements on the site are to stabilize the pre-existing steep slopes with retaining walls. We have 3 tiers for the majority of the backyard and a small section on the southeastern side of the backyard, which will be 4 tiers. We're proposing 4-foot walls. We're proposing them 10 feet apart to add extra stability and some planting areas between the face of the walls. It's the applicant's intention to put vegetation in between the walls, probably at least 30 evergreens to buffer that and give them some privacy back and hide some of the walls. I know Mrs. Mayo was thinking about some gardening plateaus on it to green it up. So basically what we're doing is we're installing over 100 feet of wall, 750 feet of wall to stabilize the steep slopes that are already there. And for stormwater management, in the engineer's letter, there was some concern about what's been cleared. By plateauing this and not having an over 70% existing grade, we're actually going to be slowing down the water. It'll be cascading down. We'll have gentle slopes in between the walls, and then a modest backyard for a usable area, which will then sheet flow out to the road as it does today. So the variances that we are seeking, as I said, there are 3 different categories for the slope disturbance. From 15 to under 20%, we're allowed 40% disturbance of the slopes. We're proposing 47.2. The difference is 2,103 square feet versus 2,481. And these numbers that I'm quantifying is from this limited disturbance that we've identified on the plan and the pre-existing steep slopes within that. The slope category from 20 to 25, existing is 4252, and we're allowed 20% of that area, or 850 square feet. In that limited disturbance, we have 3,595 square feet of that category of slope. And slopes greater than 25, and I'll just pull this is the same information from the cover sheet, just with the one of the disturbance. The darkest area is that steepest slope, again, pre-existing when they bought the house. We have 12,344 square feet over 25% slope.
I'm sorry if I may, Madam Chair. So the first two categories, the numbers match up with our planner's memo. If I heard you correctly, the third one is a little higher than our planner's number. So
I didn't hear the number, actually. I thought you were quoting the amount, the total amount of steep slope.
Yeah, the 12,000 is what's on the property.
Oh, I'm sorry. I thought that was the over 25 disturbed. I'm
Yeah, yeah, and then none is allowed, and our
That I know.
proposed disturbed is 10,339
Then your
square
numbers
feet.
match up. Thank you.
Thank you. So those are the three variances. We did identify one pre-existing non-conformance. For the front yard, 75 is required. The dimension to the porch is 71.1. That's pre-existing. We're not adding on to the porch. So again, we understand that the applicant and his family had moved on with the walls and the disturbance and the cleaning up of the property. And we're here now to ask for the variances for the steep slopes in the rear. And the goal of the project is to really stabilize what they purchased, the pre-existing condition. I'm just taking a look at the review letters.
Well, while you're doing that, Madam Chair, may I ask a quick question? Dave, our planner, do we know that the front yard setback deviation pre-existed the ordinance requiring the same, or is this, for lack of a better term, a potential cleanup variance?
No, that appears to be a pre-existing legal non-conforming condition.
Pre-existing, not just previously?
Yes.
Okay, good, thank you. So the only variances are the three steep slope category disturbances, correct?
Correct.
Okay, thanks.
Do you have any, the photos that are in the application, do you know who took those?
Those were provided to us by the surveyor,
Okay.
the surveyor that did the after disturbance survey.
Okay, and it looks like they're dated autumn 2022, correct?
That's correct.
Do we have pictures pre-surveyor?
We do not. We did, I believe we submitted the Titus survey, which showed the existing house and driveway. That's what we got for the existing improvements. And just another note, there was a patio behind the house that was removed from that survey. We're proposing a new patio. The net increase in impervious coverage is under 1,000 square feet. We're at 993.
Yeah, I saw it was just under 1,000, so I guess we'll get to that when we speak to Mr. Quinn. Any questions for Mr. Miller before we hear from the applicant? Go ahead.
Before you were retained, were there any drawings that had been prepared for the walls and the grading?
There was not.
This
There was
just
not.
being done, like,
They did their own construction in the field, and then the town, they had to stop work order, and then my firm got involved.
And what was the date of the stop order, do you know?
I do not know.
Okay. What was the date you were retained?
I know we started talking in the fall.
22?
I believe it was October 2022.
Okay. So prior to that? Probably. When you were retained, there was already a stop order in place?
Yes, that's correct. Yeah, October 28th, 2022, we were retained. I don't have a copy of the stop work order in my file.
Okay. Since you mentioned the impervious coverage, do you mind, Mr. Quinn, I saw you have some comments with respect to, I appreciate that you're under 1,000, but very close to 1,000. Just wanted to get your thoughts on that.
Yeah, they are very close to 1,000. Typically, if they have an impervious cover violation, we wouldn't hold that 1,000 square foot steadfast. We might request some stormwater. They're not over impervious covers, so they're legitimately a minor. I was concerned about runoff because of the change of cover, right? So, as Kathy's indicated, and there is some truth to it, she'll have to submit calculations, though. If you take a slope and you terrace it, you do alter the time of concentration, which can alter the amount of runoff leaving the hill. At the end of the day, all of the runoff leaving the hill is rushing towards the house and off the front of the property. So there are no residents or impacted at all by this development, because it literally sits in a bowl, unfortunately for them. So I don't have a problem with Kathy submitting the calculations to show that the change in grading in the back won't result in additional runoff that's coming towards the house. I think it's important to go over this, because I wasn't clear on this until I went out to look at the site prior to the previous meeting. The survey indicates, the DD survey, the topo indicates that the entire hillside has an excavated area. That's not really true. What happened was, and Kathy pointed out, the clearing that the father-in-law undertook was really back to about contour 112 on this site, which is right before the slopes start. And there are slopes on there that are 1.5 to 1, really steep slope area. And if you look at that area, it's in disrepair. It's got lots of erosion. It's not a really sightly or stable slope. I initially thought, when I looked at the plans, that they were coming in as a mea culpa for disturbing that area and now mitigating it. That's not the case. That area, as Kathy indicated, it's not been graded yet. Those grades are still the original grades. They started to clear, take some trees down in anticipation of the grading that was to come. So that area has not been disturbed yet. They're attempting to ameliorate an existing condition that's really quite untenable. But they have not disturbed that area yet, although they had every intention of doing it before they were stopped. They also went, I think the town probably stopped them as well, because all of that patio and wall area, or at least the grading for the patio area, there were no permits obtained for that.
I'm sorry, there were what?
No permits obtained from
no
the town
permits.
for that. Now, normally, that work would not have required, the bulk of that work would not have required board action, because it's all within the non-sloped area, as shown on that initial, the initial cover sheet, right? That area behind the house was all non-sloped, as they started to clear and actually provided an access. The father-in-law started to provide an access path along the left side of the driveway to get back to the slope. That's when the slope disturbance started. But the bulk of the slope disturbance they want to engage in has not been done yet. That's what I wanted to point out.
So from the 112 line
Yes.
up the hill, they haven't touched it yet? It's-
Well, they started to take some trees down. I think they
there's
cleared
no-
out
none of
some
those
trees
walls
that
have
have
been-
fallen down, maybe some live trees that were on the slope, but the slope has not been disturbed. Nothing's been grubbed or moved.
Okay, so it's just below the 112 line where the new walls have been built to date?
Yes, well, that's where the disturbance is pushed behind where the new walls are. You see the new walls.
Yeah.
The 112 line expands behind that. That's the area that's all been cleared and vegetation is removed and
Right.
totally denuded. Behind that, from the 112 all the way up, that's all the natural slope that's there, and it's
Not-
quite a slope.
Yeah, nothing's, I drove by it and I
Yeah,
saw it. I
yeah.
couldn't tell where the walls were though in relation to the slope. So the walls that I saw that had been built, the 4-foot-high terrace walls, are all below that 112?
Yes,
Okay.
yes, about 25 or 30 feet towards the house.
So are they not yet in the steep slope area?
Well, they are. They have not disturbed the slope to the east of the property, but along the driveway, as you heard, yeah, right. That knob right in there, yes, right there where Kathy's pointing.
So
To get
these-
around to the back, to get to the access to the back, for the anticipation of the grading in the back, they started to cut that knob. That was their first incursion into the steep slope, and they want to, basically disturb the whole backyard to stabilize it. I mean, I understand what they're doing, and it makes some sense.
Can I just ask you, though, because you say it hasn't been disturbed, isn't the removal of trees and vegetation disturbance?
Well, yes, the
Okay.
cutting of trees, technically, the cutting of trees is not considered disturbance. When you grub the tree, remove the root, I don't think that's been done there yet. I mean, you're not supposed to cut trees in the sloped area anyway, but my point is grading has not occurred there.
Okay.
I should clarify that.
Thank you. Mr. Quinn.
Is there any plan to plant trees on either the front yard, which used to be, I think, covered from the road, probably prior to you purchasing? I looked at some old pictures. You couldn't even see that house from the road. So you legally, of course, removed that and now removed some of the other vegetation.
Correct.
Besides low brush and bushes, trees that'll get, at least some height be planted?
Hang on one second.
Maybe I missed.
Yes.
I'll ask you
Let's just
first.
go one at a
Yes,
time.
the intent is to plant the terrace of the walls and also create a buffer in the front for the house.
Okay.
A house across the street, it actually started with evergreens across the front,
Yeah.
and that's the applicant's intent.
Okay, that's great. Yeah, I'm not prescribing anything, just.
Right, no,
curious on
that's
anything
the,
to be done.
I mean, that's for
A lot
their
of people have
benefit.
done that along Mount Airy to
Exactly.
block the traffic, but it doesn't need to be a wall of trees, it could be something,
Correct.
something else.
Okay.
Thank you.
I think you mentioned there were 8 to 10 trees removed.
That's correct.
How did you arrive at that number?
That was from the applicant, and again, once
Okay,
I answer
I
the
can ask him
technical,
when he comes
he'll
up,
be
that's fine.
available for questions as
Yeah,
well.
that's fine. And then just with respect to Mr. Quinn, stormwater management, since you've already touched on it, and I think you mentioned additional calculations based upon your visit to the property, is additional, even though they're under the 1,000, would it be advisable to put in any additional measures here, in your opinion?
I'm reluctant to propose additional measures on that property because it's basically already in a sump. So I don't know what the soils are like there. I think that, again, since the runoff is going to the road, it's not impacting any residents on either side. And the 993 does get them, they're technically a minor. It was only because of the extensive clearing that I mentioned stormwater. So if Kathy will submit a report, just some basic calculations for the existing condition, or the pre-existing condition, which was wooded, and the slope, with the, whatever land cover they're proposing, which is grass, landscaping, show me the time of concentration and compare the runoff discharges, I would be comfortable with that. And again, treating it like a minor so that the 993 square feet of additional runoff would not be mitigated. It would run off towards the front of the property out into the road. So that they're warranted a minor. I'd be comfortable with the calculations to show me that the runoff pre and post are the same coming from the backyard where all the grading was done.
If I may, Madam Chair, just on that same note, would you then be proposing that it would be subject to your review and approval, and perhaps it would be not unreasonable for the applicant to stipulate, or the board to impose, should the applicant not stipulate, in the event, in your opinion, stormwater management is warranted, that reasonable stormwater management would be agreed to by the applicant, given the circumstances, the magnitude, and the, well, it may not have been a mea culpa, it is after the fact.
No, I'm comfortable with that. Quite
So that was a very multi-part question. But it wouldn't be unreasonable, in your opinion, from an engineering perspective, Mr. Quinn, if the board were to impose that.
I would have no problem with that at all.
I guess then the question is, with the board's permission, would the applicant stipulate to that?
Yes, we will.
Okay, board doesn't have to
Thank you.
impose it.
Thank you. Any other questions for Ms. Mueller? Or should we bring the next witness up?
Yeah, I just had one. Oh. No, you're good. I didn't follow the numbers. There's 16,000 square feet of proposed disturbance to the slopes. How much of that has already been done?
We did not quantify the small area of steep slopes that has been disturbed just for the installation of this wall. I would approximate it at about 200 square feet that has been done. And the other area, as the chairwoman has pointed out, the brush has been cleared out, which could be considered disturbance.
Of the total 16,000?
Correct. Correct.
So for the total 16,000 square feet, there's been clearing, but only the 200 square feet, there's been grading.
There's been a small area of grading. The other is all still at the pre-existing grade.
Thank you.
You're welcome.
Okay. Maybe Dave, should we, while Kathy's still up here, we should go through your memo, if you don't mind?
Sure. Looking at my August 21, 2023 memo, comment number 1 is just factual about the numbers we went over. Comment number 2 is citing the ordinance provision that allows the board to require a conservation easement for the 25% and greater slopes that will remain on the property.
Would be reasonable in your estimation?
Well, I think maybe Ms. Muller can help out with where exactly those slopes are. It looks like they're confined to the area above the third proposed retaining wall, not quite extending to the rear.
It would be the area outside the LOD. So this area in the LOD, we're actually flattening out with the installation of the wall.
Well, that's, your proposed grading, I think it shows about 33% slope there. I mean, flattening out compared to what is now.
Yeah,
But,
3-on-1 would still
yeah,
be
anything over
considered a steep
25%
slope.
is where the ordinance gives the board discretion to put that in a conservation easement. It's that upper area, and that's at the board's discretion.
Or if the applicant stipulates, well, it's still up to the
Yeah,
board's
I mean, is the
discretion. They don't
applicant
have to
proposed
take
to
the
do anything
stipulation.
up there, I guess is a question.
We don't intend to have additional disturbance above the wall after the project is done. So we'll take the guidance of the board.
There is some disturbance in that northern portion above the third stacked wall that you're proposing now. And it does appear, in my opinion, that this disturbance might need to do something to further stabilize the area there.
Correct. So this gray dash line beyond the third tier is our limit of disturbance.
But you're saying you're not going to disturb beyond the gray line, the dash line?
Right, but when the project is done, up above this third wall, between the third wall and the limit of disturbance will be stabilized. If there's anything beyond the back of that that may be unstable, that'll be corrected as well.
That's because I visited the property and talked to the applicant today, and during that time, I think we both observed some area right up there where that, I don't know the lot number up there. There's a corner fence post there, and the soil right by the corner fence post has been compromised, and it's very, very steep right there, because that soil was touched. So I'm just saying, what kind of stabilization is gonna be done there? I mean, I see the line for the LOD, but that has nothing to do with my question.
So
It's
to
already
the
been
east
disturbed.
of the LOD, there's an area of concern
Yeah.
in here? On,
No.
is it on
Right
this?
where the 2 points meet on that lot line. I don't know the lot. You don't show the lot on the drawing here, so I can't comment on it. But
This is lot 21 with the house to the kind of northeast, up in this area?
yeah, whatever. No, you don't show lot numbers, but my point is right up here. Whatever lot this is. Doesn't
I don't
say-
know which map that,
It's that dash line that's going straight
This
up.
one?
Yeah,
Oh.
that one.
oh, on the survey.
Yeah, this lot right here. No, lot, it doesn't say the lot.
21.
So the lot line between 19 and 21.
Right there, right, between 19 and 21.
If there's an area of concern that's being eroded, it'll be stabilized as part of the project.
There's only so much of your property there.
Right.
With the exception of the possibility of a small area needing to be stabilized, would the applicant stipulate to the conservation easement for the portion that was described by Mr. Schley?
So just to clarify for future reference, Mr. Schley, if we did it approximately at the 130 elevation line,
Well, I'm thinking the third retaining wall would be a good marker for where the easement could start.
Right, I'm just going to the 130, just, it's a couple feet behind it, just in case there's maintenance to the wall, or would that be allowed in the
I
easement?
think the easement would be written to allow the structures that are in it and maintenance of those structures.
We can draw it along the third,
and
and then the
then-
fourth wall.
I guess the question in my mind is what would be going on beyond that? If that area is put in a conservation easement, then any activity, I don't know what would be happening back up there on the hill, but why not just put everything rearward of that into a conservation easement? That would actually be contiguous to a conservation easement that already exists off-site.
And that would be our best path for protection back there, in your
I think
opinion?
so, because you'd be creating a the earlier discussion would be creating a conservation easement, like a donut hole, that would be allowed to be disturbed all around it. If you would have a nice neat demarcation, the third retaining wall, rearward, it's about 75 feet from that wall to the property line. If you put that in a conservation easement, then it's pretty clear.
We
Yeah.
have no objection to that, just one clarification point. On the southern, southeastern side, we have 4 tiers. Would that top tier, would the
Yeah.
easement jump to that 4th tier and follow that, or put that 4th
Well,
tier
I
in the
think
easement?
between the third and the fourth wall, you got a 33% slope, I believe. So if you just left it at the third, I mean, I don't think it matters, really.
I just want to, I can draw it up for your review and
I think
comment.
I would just say 75 feet from the rear 75 feet of the property. That may not quite coincide exactly with the 25% slopes, but how 25% is calculated is really, you can do it a couple
When it's
different
done,
ways. I think
The review and approval of Mr. Schley?
Yes, 75 feet off the rear lot line.
Yeah. Thank you. That was comment number 2. And comment number 3 is just referencing there's some notes that appear to indicate relief is required for some of the walls in the front of the property. That would only be required if they're freestanding walls, but my understanding is all the walls that we're talking about here and shown on the plans are retaining walls.
That's correct.
So you'll revise a plan just to eliminate that. In other words, the retaining walls are conforming, other than for the fact that steep slopes were disturbed or proposed to be disturbed. Number 4, it speaks about a safety barrier or something to be provided along the top, or at least the uppermost wall to, just as a safety measure. I think the Environmental Commission may have raised the same comment. I don't know if anything's proposed, if the board thinks anything is necessary. I was thinking along the lines of a wire, a 4-foot-high welded wire fence. If anything, you wouldn't really see it. It would keep deer and anybody else, kids or somebody climbing up there.
Yep, and to Dave's point, we did have that comment from the Environmental Commission that said the applicant should consider a safety fence on the upper tier, the highest east retaining wall for wildlife safety. Is that something you would consider?
I don't have the benefit of having the Environmental Commission review.
I think it was just read to you, so at least for
That
that.
was-
If that's the one point, we'll put the,
There are other points, but that's the point.
It's the only one we're talking about
That's the
now.
one we're talking about now.
correct,
Is that acceptable to STIP?
yes.
Number 5, it speaks to the tree removal. That would include the 8 to 10 trees that were removed and the additional trees that have not yet been removed. I mean, this is pretty typical with any variance application. The board typically likes to see replacement trees. I think we have a great spot for them up in that conservation easement, or any other landscaping you plan to do on the terraced areas. Is that something, I don't know if the board needs to see anything or can defer that to the engineering department.
Yeah, we're comfortable
Generally
deferring that if you're
speaking,
comfortable.
we'd be
doing so.
Understood.
looking for a 1-to-1 replacement, something on the lines of a 6-foot-high evergreen or a 2.5-inch caliber shade tree or a good-sized ornamental tree.
Yeah, maybe we could
We'd
say
agree to that.
at least
Thank
10.
And my last
add that 8 to
comment,
10.
number 6, is just that the Soil Conservation District, I think Mr. Quinn already mentioned certifications required.
Understood.
Ms. Miller, while you're still up here, Mr. Quinn, I know you've made some comments already, and we probably went out of order on your memo, but if you wouldn't mind addressing some of the points that haven't been addressed already, make sure that we are fully covered.
Sure, we talked about the walls, the rail on top, SCD I had,
Great minds think alike.
yeah. We talked about the excavated area, how it had been not graded yet. Yeah, and this will be something that you'll have to deal with township engineer.
Can you just give us a number, Tom?
Number 6, this is the retaining wall. Anytime anybody uses boulders for retaining walls, it's a non-standard, uniform construction size, right? People build with walls all the time, but the detail on the drawing is so cursory that I don't know if the engineering department is gonna wanna see structural calculations for those walls. They're gravity walls, basically.
Correct.
So you may have to give them some minimum dimensions for the gravity wall, just so you can design a gravity wall. They may want to see calculations for that, or certification. I'm not sure what the department's gonna want to see, but be prepared to do calculations for those walls, and for the stone walls, at least give them some mass dimensions, so they know how big a stone they need to provide the stability is required.
Correct.
Just beware of that. That'll be outside of.
I spoke to the applicant as the construction's coming out, going along. I'll go out to the site and take a look as they're building it.
Okay, you'll have to satisfy the township engineering department on that, once you leave here. I did, number 7, I did find out where the access was when I went out to see the site. That had, father-in-law had constructed it around the outside of the wall. And then I think we talked about the stormwater. Again, it's totally up to you because of the grading disturbance limits. I'm expecting at least calculations. If there's other requirements that you decide to apply to the application, I'll follow those through as well.
Okay, just with respect to that comment, how did we think about it? Because we're gonna get the calculations, but if you get the calculations and the runoff for some reason is not the same or is worse than it was before, what are the next steps there?
Well, here's the thing. If she's gonna do calculations, the calculations were intended to omit the 993 square feet. We're gonna be neutral on that because that's under the minor development. They wouldn't normally have to mitigate for that. So I was focused on the clearing area in the back where the surface cover has changed. I wanted calculations for that area. If we throw in the patio, any increase in impervious cover, we're gonna increase runoff. But the township code allows some of that with the minor development threshold. So I was looking only at the back
Thank you.
cleared area and was leaving the 993 for you guys to decide, but it does fit under minor.
Do you have any concern about like any kind of runoff onto Mount Airy Road as a result of this project? Because it's, when you say it's in a bowl, the grade does slope down
It
towards
does,
Mount Airy.
from in front of the house, it
Right.
does. It rapidly, I mean, it must have been something to see before. And now I think I understand why the father-in-law was back there with a machine trying to grade the backyard, because it's, if you look at the topo, it's just a huge amount of slope
Yeah.
coming to the house. And then it flattens out where the house is and does continue out into the road.
Right.
But it doesn't go left or right. It does eventually travel out to the road. So and I think they did some flattening. When I was out at the site, Mr. Mayo was telling me that they did some clearing and leveling in the front yard to level that as well, and to get the drainage to not sump in the front yard, but to get it off the. So I mean, it's all going there now. There's no change in drainage pattern at all. So I'm not really overly concerned that there's gonna be a problem in the street.
If I may,
Yeah,
Madam Chair,
please.
and I apologize for belaboring Mr. Quinn, but since there does seem to be some concern expressed by some of the board members, What would happen if the 993 and the area you're concerned about were combined? I assume we would have a major. And what would that entail potentially?
You know, I think I misspoke. It's exempt. At under 1,000 square feet, it's exempt.
Yep.
I keep
No,
saying
we appreciate-
minor.
I get-
Okay,
I get
yeah,
that part.
Because I think I misspoke.
No, I got it.
If, once it's over 1,000, it could be a minor. So with the grading limits, with the disturbance area, coupled with the 993, you could consider it a minor if you wanted to. So the 993 square foot, that would be exempt. But again, because
Still
of
a
the
minor.
clearance limits, I was looking at it kind of like a minor development, so I wanted to see the calculations again, but I was only focused on the back area. If we
it
want
were
a
a
whole
major-
net for the site,
Yep.
we're gonna end up with some sort of detention on that site, because that's just the way it works.
Which the soils are clay, we've been out there. And one other thing that I want to point out is this project was stopped in the middle of it, probably at the worst condition that it could have been at. And we haven't had any complaints. Obviously, it's not flowing towards any neighbors or from the county roads. So what we're proposing to finish the project is certainly going to improve the conditions greatly from what's out there now.
The calculation for impervious cover are only for the limits of the project, correct? Because I guess what I'm getting at is, there's a huge amount of gravel area on the property, the whole backyard, the driveway, all of that, so that would preclude it from, how would I say this, for ever being covered. I mean, not paved driveway, not a patio.
The driveway pavement as, the driveway gravel is included in our impervious coverage calculus. Yes, it is.
Just, you know what, while we're on that, just clarification, because I had this on my plan and I forgot to ask, but the area that's shown out in that back, inside that retaining wall, that's all gravel now?
Yeah.
It's
They
a
have
mix of gravel and weeds.
Okay, they have a small patio shown, the rest of that's gonna be green.
That's correct.
Right, okay, because that's what the calculations would support.
Correct.
Okay.
Okay, maybe we can hear from the homeowner. Before we let you go, I want to ask the public if they have any questions for Ms. Mueller. Without seeing any, do you have another witness?
We have Mr. Mayo here if the board has some questions for him.
Right? Mr. Mayo,
Yes,
I think we heard 8 to 10 trees were removed in the back. Did that number come from you?
yes.
Okay.
So there was a-
How
there was
did
a-
you come up with that number?
There was actually 5 or 6 that was removed in the front of the house.
Can you do me a favor? Speak right into the microphone, sorry. just so everyone
There was
can hear.
actually 5 or 6 that was removed in the front of the house.
Uh-huh.
There was 1 hugging the back of the house, and there were 3 up on that hill that I took down.
Okay. And-
3 or 4, I mean, give or take.
Okay. And who were they removed by?
They were removed by me and my father-in-law.
Okay, you and your father-in-law?
Yes.
Okay. When was that?
Probably August, September of 2020.
Of 2020?
It was right after I had my son.
Okay. Do you have any pictures of the property prior to starting this project?
The only thing I might have is I have the brochure when I bought the house.
Hmm.
There might be some pictures
When
on
did you buy
there.
the house?
I bought the house March of 2020, right in the heart of COVID.
Did you hear from any of your neighbors about the project while, either before you were doing it, while you were doing it, after the town asked you to stop?
Yes, both my neighbors came by and told me I was doing a great job.
Okay. When you say both your neighbors, does that mean the one on your left and the one on your right?
That is correct.
Okay. Are any of the steep slopes connecting to those two properties on your left and your right on Mount Airy, were they disturbed at all? Because those are pretty steep, right, between the two properties. Have they been touched at all, or are they stable? Well, any comments you'd make about that?
So, to Kathy's point, you know, I really didn't start cleaning the slopes. This was kind of my father-in-law helping me out while I was having my baby. But the slopes were there already. I mean, when I bought the house, they were steep. I mean, our intention was always to clear the property out in the back. It was just all overgrown, brush was thrown back there, just over the years. So, where the houses are on each side of my house, the slope does start to come down where it becomes flat towards the street. It's not the steepest point of the slopes. The one on the, you know, the area they're talking about that was disturbed, yeah, that, a little bit of on her hill was disturbed. But on the opposite side, I never disturbed any of that property.
Okay.
So I don't know if I could show him with the mouse, but to the right-hand side, you know, he was out, you know, the gentleman was out there today, and none of that side was touched. It was only the left side of the property. Yeah, so all the disturbances was done here. All this side, none of this was really touched. You know, if you go to the property today and you look in the backyard, you'll see some dirt here in the middle. It was just the dirt we removed from here and brought over here. My intentions were always to put walls back here.
Okay.
Even besides I was, you know, this is all new to me, but the steep slope, when I got the letter from the town and they were like, you need to come down and talk to us, I was like, oh boy. But my intentions were always to make the property beautiful and put up walls.
Okay. And what was the purpose of the project? Was it stabilization? Was it backyard? What, like,
Yeah,
what
so
was the purpose?
So right here where I put existing walls, so when they built the house, I'm the second owner. When they built the house and they blew out the mountain to put the house here, all the rock and shale, they had built walls already. There was existing. When I bought the house, they were all just falling apart, you know, just from over the years. So that I replaced. Here was always flat, but it was just a very small area. And since I had a lot of property, this was more of like it wasn't very steep, but there was a hill there, so I wanted to make it flat to put like grass and put a play set for my kids. That was always the intention.
Just one question. Do you do this for a living, and does your father-in-law do this for a
I
living?
did it, I don't do it today. I'm in corporate America today. My father-in-law, I'm Portuguese, my father-in-law's right off the boat, and in their country, they just, you know, they just do
No,
whatever they gotta do.
I'm only saying this, that's great that you can do it.
Yeah.
Many people can't do it.
Yeah.
The other occurrence of someone doing something like that, they rented a backhoe and ripped up their backyard.
Yeah, so I was-
I'm only asking in future, the work that you will be completing, is that gonna be contracted, or are you going to do the work also? And how are you gonna monitor it so that we don't have any other possible issues? You know?
Yeah, so my father-in-law will probably be helping me. He's kind of retired, so he'll be helping me do the walls.
Okay, so you're still gonna do all the work yourself?
That is correct,
Okay.
with the engineer's supervision,
So
obviously.
you're gonna be monitoring the work, and, okay. I know it's gonna be, the city's gonna monitor it too, I'm just wondering if, you know, when you take a backhoe somewhere, you don't get to make a mistake too often, right? It's gone if it's gone. You
Yeah.
Try to put it back, so, okay.
Madam Chair, one quick question, maybe for the engineer, or both engineers, but is it fair to assume the slopes are man-made and not natural? That they were probably just pushed back to make the flat area for the home originally, or do we have any indication one way or the other?
It's hard to imagine that the slopes that are that far behind the house were created when the house was constructed. They would have limited the area, as Peter is mentioning, the area, they created a little flat spot in the middle of, a little bowl in the middle of this hill. So my impression is that everything from like the 112 contour back up the hill is all the way it was naturally, even certainly when he bought the house, but I think even before the house was built. Because I don't see the purpose for hacking into that hill and leaving a 1.5 to 1 slope coming right down to the house.
Because if I understand correctly, a slope's a slope, and if it's disturbed, it's disturbed, but there's some consideration given, I guess, if it's a man-made slope, that might not necessarily be given if it's a natural slope. Is that
Well, and
fair to
usually
say?
man-made slopes are limited in fetch. You know, they may be 15 or 20 feet, like localized slopes, like the mound around the driveway that was there. You see the knob that was up to the north of the driveway, that's obviously a man-made slope left. But a fetch that long behind the hill, I don't think that's man-made.
So it's fair to say the board should be all the more concerned with disturbance of natural slopes as opposed to man-made slopes.
Oh, all slopes, definitely, but particularly natural slopes. because
That's my point.
They tend to be a longer fetch and not localized like man-made slopes.
Got it,
right?
thank you.
Makes sense, thank you.
Was your driveway that size when you moved in, or did you enlarge it after you built the walls?
Yes, so the only thing I enlarged is I brought this out a little bit.
And my other question is, do you get water in your basement from water coming down the hill? Like, do you get water coming in your basement when it rains?
Yeah, I
Water
didn't
flowing down?
prior and I don't today. I don't actually have a basement, it's a bi-level.
Oh, okay.
Any other questions for Mr. Mayo? Okay. Does the public have any questions for this witness? Anything else, Mr. Mayo?
No, that's it. Thank you.
The only additional question I have, is there any lighting going up or anything like that beyond the, you know, the terracing and the additional shrubs and trees? Anything else?
I'll probably put landscape lighting in the back.
Okay, just downward facing landscape?
Yeah.
Okay, thank you.
Would be subject to, well, I think you got it.
Okay, thank you. Are there any comments from the public on this application, for or against this application? Okay, see, yes, one. Can you please come up to the microphone, please?
And
You
you just
can-
need
go
your
ahead.
name, address, and I'll have to swear you in.
Keith Spiro, 3 Princeton Court, Basking Ridge.
If you raise your right hand, do you swear to God or affirm testimony about to give is the truth, the whole truth, and nothing but the truth?
You got it.
I'll take that as a yes. Thank you.
You got it. I only have one comment. I have no association with this property. I have no skin in the game. I just want to commend the guy for really making Basking Ridge better. I mean, the guy obviously just went out, took it on his own. Whatever the rules or regulations, from my viewpoint, listening to this, thank you. Just thank you for doing that. That's all my comment.
Guys, thank you very much. Only person at the microphone, please, please.
We'll
let's
take
keep
that as a
going.
comment in support of the applicant.
Exactly. Are there any other comments for or against this application? Okay. Any other comments from the public? Okay, seeing none. Ms. Mueller, any other further comments, or you want to turn it to the board?
We'll turn it to the board.
Okay, thank you.
And if it helps the.
Yes, it
Madam
would,
Chair,
always helps.
I believe the board is considering a motion potentially to grant the application for the steep slope disturbances at the 3 category levels in the magnitudes requested and documented in Mr. Schley's report, along with all the stipulated 2 conditions set forth in all 3 memos, the engineer's memo, planner's memo, and environmental commission, as well as the stipulation with respect to the calculations provided for to Mr. Quinn, with the possibility, subject to his review and approval, of stormwater management if deemed necessary as a result thereof. That's actually part of one of his conditions anyway, but it was added to. And also the conservation easement, which is also an existing condition in Mr. Schley's report, measured along the 3rd retaining wall rearward, and roughly 75 feet from the rear property line, particularly in that southeast corner, if I recall correctly. I think those were all the conditions. If it's a motion in the affirmative, which would require a majority of the board for passage.
Okay, thank you, Mr. Warner. Okay, open it up to the board if there's any comments or deliberations on this particular application. I'm happy to start. I'll start. I'll start. I have been to the property. I actually think it's lovely, actually. It looks quite nice. I will say, though, that applications like this dishearten me. You know, this board, I think, collectively spends, I don't know, collectively over 1,000 hours a year trying to review applications, listen to requests from the town, and grant them if we feel like they are within the rules, and also set certain mitigants if we think that there are certain risks. So on this one, we weren't given that opportunity, which, you know, I think yeah, it disheartens me. You know, I think we very well may have granted the request, but that's irrelevant, right? We just weren't given that opportunity. So I think an application like this, you know, we can't very well say, no, we can't undo disturbance. All we can do is, you know, try and put in future mitigations and make sure that the work that you have done up until this point is, you know, stable, and that it's good for the town. So I appreciate the stipulations that you gave us, which I think Mr. Warner covered well. We're going to replace trees. We're going to put a conservation easement there. We're going to put a wildlife safety fence. So I appreciate all the work that you do. I appreciate the position that you were in, and notwithstanding, you know, where your father-in-law is from, you know, we're Basking Ridge. We do have rules, and we try to make sure that everyone follows them.
For the benefit of all residents.
Yeah, for sure, everybody.
Madam Chair, I guess the lesson learned is always check with your building department before doing any work on your property, so you don't wind up in a situation like this. You know, we see it quite often, and it shouldn't be. But I am familiar with the property, and it was in need of cleanup desperately. So it's a great improvement. The stabilization of the slopes is definitely got to be an improvement. The benefits will outweigh the detriments. The property itself, the shape, the slopes, I would see it as a C1 and C2 variance, and I would be in favor of granting.
Thank you, Mr. Tancredi. Is there a second?
I'll second it. I think the design that Ms. Mueller put together is a very nice design, and it will add to the beauty of the property. So I second it.
Thank you, Ms. Proctor. Ms. Kiefer?
Mr. Cambria?
Yes.
Mr. Kraus?
Yes.
Mr. Pavlovsky?
Yes.
Ms. Pakhtar?
Yes.
Mr. Tancredi?
Yes.
Ms. Herrera?
Yes.
Chairwoman Juniors?
Yes.
Thank you.
Thanks very much. Thank you. And apologize again for pushing you to tonight. Sorry about that. It was not on purpose, for sure. Okay, Ms. Pakhtar, I think you're going to leave us. Yeah.
Let the record reflect that Board Member Pakhtar is leaving because she's recused from this matter.
Thanks for coming in. I appreciate that. Okay. Next item on the agenda is item 9A, which is the continuation of the signature applications application, which is ZB 22028, signature acquisitions.
Again, board members, Madam Chair, members of the board, members of your professional staff, members of the public. My name is Jeff Lehrer from the law firm of DeFrancesco Bateman. I'm not going to reiterate what this application is about. I've done it 4 times already. I think people understand that this is an application for preliminary and final site plan approval together with D-variance relief. One of the overarching observations I have had listening to the testimony thus far, and is that, and listening to the other professionals on both sides, is that there seems to be some confusion from a design perspective about the difference between a warehouse and a light manufacturing building. So I just, as an observation, to make things simple for the board members and the public, there is, with minor exception, little difference between the two. It's rather the use put to the building which should be the focus of the board and the public. Light manufacturing activities can take place in buildings that are warehouses. Likewise, warehouses can accommodate a large variety of uses like workshops and studios, labs, retail, showrooms, event spaces, gymnasiums, and sport facilities, agricultural uses. The distinguishing factor, the distinction between warehouse buildings design and light manufacturing building designs may be somewhat negligible. The distinction between the two types relates to their use. And it's determined by the types of users and the tenants, and not so much on the building design. For example, you may all know Zone Baseball Academy or Hoop Heaven in Bridgewater are examples of athletic gymnasium-type uses, but they take place in...
I'm sorry, I apologize, but I think is Mr. Simon objecting, or is he raising his hand for a different reason?
I am not raising my hand for the sake of raising my hand. I don't really understand what Mr. Lehrer is proffering here. He's not a witness, he's not sworn, he's not providing legal arguments.
I'll get to the right to the point.
And, no, well, but
Yeah.
I don't understand, like, none of that should be in the record because it's not being provided by a witness that has been sworn, and it's not legal argument. So, I
am
want some
getting
clarification
to
here.
the legal aspect, and I'll get right to the point.
If you're making a proffer as to something a witness is going to testify to, I suspect Mr. Simon has no objection to that, if it's a proffer that a witness is going to testify to.
Yeah, and all he has to do is say, I have a witness.
Right.
At the appropriate time, who's going to say X and Y.
Understood. I also suspect there might not be an objection if it's argument, although I don't quite understand why the legal argument would be frankly done right now, because we're in the midst of testimony.
Yeah, my architect is the one that's going to be the person next up, and he's going to be
So you're making a
cross-examined.
proffer as to what the architect's testimony
Yes,
is?
in summary, what I'm really saying is what he's going to ultimately conclude, and where he's going with this. So I'm just making a proffer right now. So if, I'm not asking you to strike anything, I know Mr. Simon is, but I just was making an observation based upon what happened at the last meeting with architectural testimony, and we're gonna get there. But with all due respect, I'd really just want to get to what the point is. So if Mr. Simon would indulge
If the point is
me.
a proffer that the architect is going to testify, my advice to the board is to permit it. Is that what you're
Yes.
offering? Okay.
My only comment is that I'm a little confused because I thought the architect already provided some direct testimony, and various people, including, I think, my office, had an opportunity to cross-examine. Is what Mr. Lehrer is getting at is that the architect is going to be providing additional testimony? Because if that's the case, then certainly the
That's an
public should
excellent point.
reserve its right to cross-examine.
That's an excellent point. If you're making a proffer, but he's on cross, I think, that
So-
might be a little out of the ordinary.
You know, sometimes the rules of evidence don't necessarily apply in land use hearings, and many
Not
times
strictly,
lawyers
that's correct.
make certain observations about what they've heard thus far. That's really all I'm doing, and I'm getting to the point. If Mr. Simon would just indulge me, I'll get there right now. In light of the foregoing, the applicant makes the following stipulation, or you call it a proffer. For any new tenant or change in tenant, regardless of whether the tenant fit-ups are to occur or that the tenant or the property owner must first reach out to the township zoning officer prior to occupancy by the tenant of the space and seek permission of the zoning officer that the tenant proposes to use the space in a way that's permitted in the E2 zone. In essence, the board can feel assured that any tenant is a light manufacturing tenant. Hopefully, this should put a rest to the issue out, whether a warehouse or a light manufacturing building is proposed. And with that said, I will go to Mr.
Well, I understand the stipulation I understand now that you're not proffering any testimony nor making a legal argument. I guess you're offering a stipulation. It's a third item, in my opinion. And as a stipulation, just so I better understand it with the chair's permission, before Mr. Simon and others may wish to make further comment, is it in essence a stipulation in perpetuity to provide an informal mechanism for consent to any change in tenancy to ensure that the use is conforming?
That's exactly right, Mr. Warner. That's exactly right. Because there had been, you know, as an attorney, we know what the issues are that the board is throwing out. We know what the issues are that the public is and the objectors are throwing out. And it appears that after all is said and done, there is a mechanism to make sure, whether it's a light manufacturing or a warehouse, it's not a warehouse, but but the buildings are built the same, and the architects testified to that, but there's a way that you can safeguard for that, and the way is through the zoning officer. And we're saying, if he comes in, any tenant that comes in will get a zoning permit to prove that they are a light manufacturing use and not a warehouse use. That's all I was saying.
Well, if it's a stipulation that's offered, we may not want to belabor the point, because certainly anyone and everyone can comment, including council, on the entirety of the application, including any one or more stipulations that are offered. But I think I, and perhaps the board, understand what the offered stipulation is. I leave it to the chair if you wish to indulge council on further potential commentary or objection.
Thanks. I just want to make sure I understood what you said with respect to the potential stipulation. It's basically just, you'll double check with the board?
No, you have a gatekeeper. The
Okay.
gatekeeper is your zoning officer.
But the law is we already have that
Right.
in the guidelines. So your stipulation is just that you'll double check to make sure?
Now, any tenant that comes in, any tenant.
But it's a double check, right?
It's a
not-
double check,
Okay.
because the public may not understand that there is a gatekeeper that is there to make sure that the person going into that space is indeed a light manufacturing user. And so I just want to make it clear for the public, based upon what I've heard, that they may think that this is going to be a warehouse, you're lying to us, you're not telling us the truth, but there is a gatekeeper.
Understood.
We can proceed, I believe.
Okay, thank you. Mr. Neighbor?
So as a reminder to the public, Mr. Neighbor, I think testified several meetings ago, but Mr. Berlin, one of the objecting lawyers, did not have an opportunity. I think we ran out of time with respect to the cross-examination, and I think it was supposed to happen a meeting ago, and then you couldn't make it.
Yeah.
So we're going backwards a little bit, but this is the cross-examination by Mr. Berlin.
Hearing
Welcome back.
3 on June 7, Mr. Neighbor provided his direct was crossed by both of the other objectors' counsels as well as the public. This is now hearing 5. He's here to be cross-examined by Mr. Berlin.
Can everybody hear me?
Yes, thank you.
As you said, this microphone has
It's
its
not good. We can hear you well, though.
disadvantages. Good morning, good afternoon, good evening. That's how it's, after 7 appearances.
Hopefully, we won't get to good morning. but-
We no longer know which is which. Sir, when were you retained to design the building at 150 Allen Road?
I don't know the exact date, but it was
Will you
approximately.
please use the microphone?
All right. I'll move it closer. Okay. Probably about a year and a half ago is when we started the project.
Which would be when, a year and a half ago, approximately?
I don't recall.
So sometime during 2022?
That would be correct.
Yeah, all right. Had you designed any other buildings for Signature Acquisition, either prior to the time you were retained on 150 or since?
I've done work for Signature Acquisitions. I've not done a ground-up building for them.
What individual at Signature Acquisitions hired your company to do this work?
Mr. Travellini, Rich Travellini.
This name has appeared in some of the emails, and I'm just curious as to who he is. Who's Shalomi Reichman? Do you know?
He's one of the, I guess, partners in the
He's
company.
connected with
He's,
Signature
yes,
speak up.
he's part of the company, so.
Your company?
No, Signature Acquisitions.
Why does that matter?
It was a name that's bandied around.
But this is architectural cross-examination.
Yeah, let Mr. Berlin, you're,
Yeah, so I'm
Mr.
not
Berlin,
going any
I haven't said anything yet, other than Mr. Berlin.
He's
Mr. Berlin?
somebody at Signature
Mr.
Acquisition.
Berlin?
That's fine.
Mr. Berlin, may I speak? You're familiar with what is relevant in a land use application, what's material and might even be irrelevant. Can we please focus on the material and relevant in your cross? Thank you.
It's probably irrelevant. I just didn't know who that
We
person
understand.
was.
Please,
Okay?
please
All right.
proceed.
Did you or somebody else from your company have an initial conference to discuss the building at 150 Allen Road?
Yes, the people in the firm
And
did have a,
who was present at that initial conference?
I believe that was Stephen Quick. He's he's a partner at the firm.
I'm going to have to ask you to try and talk a little
He's
louder.
Stephen Quick. He's a partner at the firm.
Which firm?
Perrette Samjian Architects. Sorry.
Were there subsequent meetings that you attended involving the development of the building at 150?
Yes, there were.
Approximately how many?
I mean, I was on meeting calls, probably a half a dozen. Mr. Quick, who's our designer at the firm, is the one that did the initial meetings and
Do you have any
designs.
notes of those meetings that you made during those meetings?
Objection. Attorney-client work product.
There is no attorney-client relationship between an expert who has been hired.
Yeah, but there is work product doctrine that could be relevant to work done by consultants, but, this is an administrative body, as you're aware, a volunteer board, in fact, that is hearing land development applications. Mr. Berlin, respectfully, not the United States Supreme Court or a trial court, district court, state court, law division application. So if you're trying to set up a basis to subpoena notes or what have you, you might be going beyond what's normally the parameters of a land development application before a zoning board of adjustment in a municipality. So I'm just trying to anticipate and make sure we're all on the same
Well,
page.
I think the question only requires a yes or a no.
If it's if that's the last question
Do you
about
take
notes?
or do you not take notes?
I typically have a pad with me and I jot down
I think the answer is
relevant
yes.
information, yes.
Now, what is our job tonight? Is it not to help present facts necessary for the board to decide whether to grant 24 variances and exceptions?
Objection. What's the question that relates to architecture? If he's just paraphrasing what this
Mr.
Mr. Berlin,
Lair,
is that
would
the
you
question,
give-
Mr. Berlin, is that the question for the architect?
Pardon?
Is that a question for the architect?
Yes.
Okay, please finish your
And
question
I
to the
wish
architect.
Mr. Lair would not interrupt, as he has a tendency to do.
Now, Mr. Lair, I'm going to advise the board that allow Mr. Berlin to ask his cross-examination questions. If they're relevant questions, so be it. If you have an objection, please make an objection. But please please allow him to continue. Mr. Berlin, please direct the questions to the architect and
I'll
make sure
repeat
they're at
my
least
question.
relevant to the land use application before us.
Isn't our job tonight to help to present facts necessary to this board to decide whether to grant 24 variances and exceptions to allow two buildings totaling 258,000 plus square feet to house light manufacturing office facilities on Lot 3, which contains 28 acres, and allow 24 loading docks large enough for large tractor-trailer vehicles, which may transfer residential areas while coming and going. Isn't that
Objection.
correct?
It's a statement, it's not a question.
I'm asking whether that is,
Mr. Neighbor, if you could answer the question, ask the question. Mr. Berlin, recognize he's the architect. The point of this is to question him on the substance of his architectural
Right.
testimony. That's relevant to the land use
Right.
application. That's why we're all here. If you can answer the question as best you can answer.
Well, again, we're here because there's features in the site and the way we're proposing the development that require approval because they don't fall within the current zoning ordinance regulations.
now, you have been involved with this because you're the architect and you are the one who has drawn the plans. Isn't that correct?
Yes,
All right. Now, you've been here, I couldn't help but notice, for hearings February, March, April, May, June, August, and now September. Isn't that correct?
that's correct.
And you've listened to the testimony?
Yes, with all the exception of the last one, which I could not attend.
And you and the engineer have been successful in describing to the board the details of the proposal. Isn't that correct?
I believe so, yes.
All right. So let's develop the facts that are necessary for the board to decide in accordance with the pertinent statutes whether or not to grant the variance from an architect's point of view. All right?
Okay.
Good. Now let's talk about parking.
I'm sorry, let's talk about what, Mr. Booth?
Parking is better answered by the civil
Please,
engineer.
please
I'm
stop.
sorry.
Parking.
Parking.
Right.
What does that have to do with?
Well, wait, just wait.
Okay.
You want
And,
to ask him the architect questions about parking?
You testified on direct examination about parking, did you not?
in relationship to the design of the building and
Of
the fact that the
course.
parking was put under the
All right,
building.
are you happy with that, Mr.
Mr.
Berlin?
Berlin, Mr. Berlin, let him answer the questions, and please do not engage in conversation with other counsel, as I asked Mr. Lair not to as well. We're going to keep these proceedings civil. We're going to keep them somewhat formal, notwithstanding my silly jokes to try
You're
to
correct, sir. I'm
break the
sorry.
tension every now and again.
Okay.
Unsuccessfully, I apologize. But we're going to, and we're going to remember, it's quasi-judicial. It's both judicial, but it's also quasi-judicial. Okay, this is not a court.
Right.
It's a volunteer board.
You testified on direct examination about parking from an architect's point of view, didn't you not?
Yes, I did.
All right. Are you familiar with the code requirements as to parking?
Yes, I am.
And what are they?
I don't know the exact number. I'd have to have that in front of me.
Well, let me
and I'd have
help
to
you
read
out.
the-
One space, as far as light manufacturing is concerned, one space for each 500 square feet, and 4 spaces for each 1,000 square feet for offices. Isn't that correct?
Without having the ordinance in front of me,
Pardon?
I believe it's correct, but without having the ordinance in front of me, I can't say affirmatively that that I'm
Yeah.
100% sure of the answer to that.
You testified, did you not, that, strike that. Have you rendered an opinion as to how many parking spaces are necessary for this project from an architect's point of view?
I believe I've answered things based on what would have typically seen in terms of
And what is that?
employee count, and that the parking that we're providing would be adequate for, based on my experience in terms of what
is
we
that
fit
figure?
out.
What is that figure?
I'd have to look at the drawings, because right now I don't.
Well, you have drawings here. Why don't
All
you
right,
look at
fine.
them?
Well, if you don't know the answer, you don't know the answer, correct?
Mr. Lair, let him testify and let him answer cross-examination questions without involvement, and so we can proceed. Thank you. And Madam Chair, I apologize for jumping in without asking your permission each time. You'll let me know when I've gone too far, I have no doubt.
Are the civil drawings here? Because I don't have the number on.
I'm sorry?
I'm looking for
Yeah,
in these
take-
PDFs, I'm just looking
your
for which
time.
file.
Mr. Warner, I'm really I'm concerned because I don't know where this line of questioning about parking is going as it relates to architecture. If Mr. Berlin can please get to the
See,
point.
no, I don't think the civil. I see see the architectural exhibits, but okay.
There, somewhere in there.
Oh.
It's
Let me see if I could help you, sir. You drew architectural drawings, did you not?
That's correct.
And did they provide for parking spaces?
Yes, they did. I don't know if I quantified them on that plan. I
Alright.
believe the civil engineer,
And the application before this board asks for a variance to allow only 328 parking spaces. Does that figure sound?
yes, that
familiar
sounds
to you?
correct.
All right. By the way, before you came here tonight, did you review your testimony that you gave in June?
Yes, I did.
Okay. Just bear with me a minute. Because I lost my place. Now, how did you arrive at that figure of 328 parking spaces?
Objection, that was not an architectural issue, it's a civil engineering issue.
I just asked him whether
Wait,
his
just
architectural...
Stop the argument. He can answer if it was him, if it was someone
This,
else. if
the
he
the
doesn't.
civil engineer and Signature Acquisitions in the discussions came
Sir,
up with that
would you
amount.
please talk into the microphone?
The civil engineer and Signature Acquisitions are the ones that
So-
developed those numbers in the,
Although- Go ahead, I'm sorry. I didn't mean to
never
interrupt
mind.
you. My question is, your architectural drawings indicate 328 parking spaces, correct?
The civil drawings do. The architectural show the ones that are directly near the building plans. I don't believe that the entire
So,
site shows, my architectural plans show the drawings on them. Or, except for under the building where that's relative to the architecture of the building.
so you at no time calculated the number of parking spaces that were necessary for this project?
The civil engineer did.
I didn't ask for the civil...
No, I did not.
You never calculated?
No, I did
correct?
not.
Okay. But are you familiar with the requirements?
Yes, I am.
Parking spaces?
Again,
So as
with
I
the building area and the things, I've done calculations
Can
based
you
on parking
tell us
requirements.
how many parking spaces the code requires for this project?
I believe that was answered in the civil engineer's testimony. I do not have the number
I'm not
offhand.
asking you what the civil engineer did. I'm asking if you know.
No, I do not.
Okay. Do you know of any, if I told you that it was 600 and...
That sounds correct.
Pardon?
That sounds about the number that,
Right. So when you started doing your drawings, did you raise any questions as to why 328 rather than 600 and something?
I was not involved at that, in terms of that, to answer, at that point, to answer the
So-
question. So I did not raise it.
You just blindly went ahead and took the 300...
Mr. Belan,
Objection.
can you ask him the questions?
I'm sorry?
You don't have to paraphrase with adjectives your view of his answer. Please ask the next question.
You at no time questioned why there was only 328 parking spaces. when
As
the
I
code
said
required-
before, I was not the lead on the design at that point of the project that would have come up. I was more developed towards the developing the elevations and the details.
When, in drawing your architectural drawing, can we put up the, it shows the site with the proposal on it.
Are you just looking for a plan? Hold on.
It's, here it is. It's site plan rendering.
Can I see that?
Color rendered site plan.
Okay. That's from. Okay, that's this.
Is this part of Exhibit 1, the compendium?
That's not it.
And we don't have page numbers
No, I
per
know.
se,
I'm trying to.
but, Mr. Neighbor, when we get there, if you could just give us the identification of what we're looking at.
All right. What's that?
Come on, let's get through this.
No, that's not
Interrupting. There you go.
Sorry, I'm not.
That's okay. Did you find it?
Yeah, I found it. I'm just trying to scroll down to get to the, my eyes aren't,
Okay. Is this the third page in? We think this is?
it's the third page in, yes.
You have a sheet number?
Hold on. It says 1. It's got a job number, site plan. Sorry. It says sheet 1 of 1, site plan rendering.
And it's just the site plan rendering, whatever one you come up with.
Yeah. Preliminary, yeah, it's just as the
Just
sheet
reduce
title
it.
is site plan
Just
rendering.
reduce it, Ed.
You had it
Okay.
before, you had it up there before.
No, it is, I was just looking to see if it was numbered.
Yeah, I think this is the third page in.
Yeah,
Exhibit.
it's 3 of the,
Okay.
the submission. Oops.
Okay. I'm sorry, Mr. Berlin. Well, can you repeat the question? Forget what we're asking. Sorry. I'm sorry.
The question was to have him pull up the.
Okay, all right. We didn't get the question yet. Okay.
Okay, that's it. Thank you. Bear with me a minute. Now, this is a drawing that either you or your company came up
No,
with.
the civil engineer,
Civil
Gladstone Designs, prepared this.
Can you tell me, is it possible, from an architectural point of view, because of the size of the buildings that you drew, to put 400 parking spaces?
That'd be a question for the civil engineer, because I don't lay out,
I'm
I do
asking-
not lay out site plans. I design buildings.
Sir, you testified on direct examination about the parking, correct? And my question is, and you designed the buildings that are shown in this exhibit, isn't it correct?
That's correct.
All right. And my question is, as a result of your design, the square footage that the buildings are taking, is it possible to put 400 parking spaces on this lot?
Not the way the,
Sorry?
not the way the site is currently laid out. I
Right.
mean, without doing, without adding to the
Now,
impervious coverage.
if it's not possible to do 400, it's also not possible to do 500, isn't that correct?
Other than building a parking structure,
I'm sorry?
other than building a parking structure and to keep it within the confines of the ring road,
Sir, you, as an architect, drew the buildings that
No,
are...
Mr. Warner, Chairman, I'm going to object to all of this. This is, he's trying to lead him down a path, Mr. Neighbor, about civil engineering that has been testified to ad nauseum. And all of a sudden, he's asking, is 500 enough? Is 300 enough? Why can't you put 500, 600? This is not the appropriate question for an architect. He designed the building. He's not the civil engineer.
Let me rephrase my question. All right? Who decided to put these buildings in this location?
as a team, it was decided to put the buildings within the ring road to maintain the ring road as much as possible. It was also, again, trying to keep the development within a currently developed area of the site without disturbing other undeveloped areas of the site, which is one of the things in terms of green building. You try and reutilize existing sites and not impose development on other future undeveloped areas of the site.
Now, the size of the buildings that you designed most certainly has an effect on the placement of the parking. Isn't that correct?
That's correct.
All right. And because of the size of the buildings, it could have an effect on the number of parking places. Isn't that correct?
That's correct.
All right. So I'll repeat my question, and I'll actually go to the final thing. You could not put 635 parking spaces on this project because of the size of the buildings. Isn't that correct?
Because of the constraints of the site, you can't, without designing a different thing like a parking structure as part of the building.
Sir, please, my question really requires a yes or a no answer. As a result
And the answer is no,
of-
you can't.
Excuse me, as a result of the size of the buildings that you
I already
designed,
answered your question. Can you please
you
just
could not put 635 parking spaces on this property. correct?
answered?
Yeah, Mr. Berlin, I think he said no. I think the board heard him say no. Thank
I'm
you.
having a little trouble hearing.
Okay, no problem. I think we heard him say no. That was your answer.
That was my answer.
Thank you.
Now, are you familiar with the present building
Yes, I am.
and the present layout?
Yes.
Can you tell us how many parking spaces there are presently on the property?
Again, it was designed for it's an office building. It was designed for office building parking. It's got a lot of parking spaces.
Do you know how many?
I think he just
My
asked you,
question
can you
was-
tell him
No.
how many?
I can't tell you
I
how
think
many.
this would be
told you-
easier if he's
Okay.
asking a question, if
You
there's a
just say
yes or a
no.
no.
All right, that's fine.
If you
No,
have more to
I
say, that's
apologize.
fine, but that's what he's
No,
looking
okay.
for.
If I told you it was approximately 700,
That sounds
does that sound
reasonable
right?
for what the, yes.
Now, because of the buildings that you designed, you had to use, in order to place the buildings on the property, the areas where parking had previously been. the
That's
700,
correct.
Right?
That's correct, yes.
Would you say almost all of the parking places that exist at the present time?
The vast majority of the parking spaces. We
sorry?
did, yes.
Bear with me a minute. So, the problem with the parking spaces is not the size of the lot, the 28-acre lot, it's the size of the buildings that are on it, isn't that correct? The buildings that you designed.
Sure. Yes.
And that's why the applicant is here asking for a variance of 328 parking spaces, which is roughly 45% of what the code requires, correct?
Yes.
Now, suppose you designed a building, what is the square footage of the building that is being proposed, that you drew?
Hold on.
Let me help you out. 258,428 square feet, isn't that correct?
Yes.
All right. Suppose you designed a building that was 200 square feet.
I was not.
200,000 square feet.
I was not, that was not what I was directed to
I'm
do.
not asking whether what
Well,
you
you're
did.
speaking in hypotheticals about design, and
Right.
we're here about this building, not what could be.
Yeah, but I'm asking you as an
Mr. Neighbor?
architect.
I apologize.
Please listen to the
Okay.
question.
Okay.
If you're able to answer the question, please answer the question to the best of your ability.
Yes, I will.
Thank you.
Assume that your plans were for a building of 200,000 square feet. That would reduce the amount of parking, would it not?
Yes, it would.
And it would also allow more space for parking.
Yes, it would.
All right. Now, let's also talk about trees. Can we agree that trees have several purposes?
Mr. Berlin, no, it's okay. Mr. Berlin?
If he'll let me
Mr. Berlin?
finish my line
Mr.
of
Berlin?
questioning, you'll see
Mr. Berlin?
where
Mr.
I'm
Berlin, can you hear
going.
me, Mr. Berlin?
Pardon?
Can you hear me?
Yes.
Okay, then please wait till I finish. This is the architect.
Right.
You're the third of the three objecting attorneys cross-examining him. Presumably, it should be on relevant material information that has not yet been covered by either of the other two objecting attorneys or members of the public who have also asked questions. You've been asking him questions about parking, now trees.
Right.
In fairness,
Yes,
this is the architect,
I understand.
the gentleman who designs the buildings.
Yes. and
That are
that's-
provided to him by the
Let me.
applicant. There has to be a reason, the questions have to be relevant,
Right.
and they have to be based on his testimony and his area of expertise. There are engineers, there are traffic engineers, there are others who have a different area of expertise. I suspect you'll ask parking questions of the traffic engineer, just a hunch. We need to stay material and only on areas that he testified to, relevant to his expertise, that have not yet been covered by the other two very capable objectors, attorneys, and the very capable members of the public who asked them questions. Do you understand that?
I understand. Let me
Okay.
rephrase my question.
What
and that
I would
be
ask,
of
on
help.
behalf of the board, if you would focus your questions in that way.
Let me rephrase my question. You made the decision as to how to place these buildings on this 28-acre lot. Isn't that correct?
That was decided as a team. We were part of the decision. on how to place the buildings.
Now, in order to place these buildings on the lot, it is necessary to remove how many trees?
That is better answered by the civil engineer, not me.
I'm sorry?
Do you know the
civ-
answer?
I do not know the answer.
Thank you.
All right.
One thing before we continue with this, so far, I just want to point out, just because there's so many people here and they come back week after week, and we definitely want to hear your questions, but so far, everything you've asked, I take fairly diligent notes if you can't hear me. And these are questions that have been answered 3 and 4 times in my notes. I could give you all these answers. And I feel that we've had other people come up and cross-examine and ask these same questions. It would be helpful if you asked other questions than the ones that have already been asked and answered.
Well, in all due respect, I'd like to get an answer to this question, which is, because of the size of the building and your placement on the property, hundreds of trees had to be removed, correct?
I believe that's correct.
And if you reduce the size of the building, less trees would have to be removed. Isn't that correct?
That's correct.
All right. Now, whose decision was it to build a building that is 258,000 plus square feet?
That was the direction from Signature Acquisitions in terms of designing the building for the site.
Did you at any time tell Signature Acquisitions that a building could be built on this premises within the code?
No,
Why not?
that is not my job. I was given a size of building that they wanted to put on the site. I fit it on the site.
Your job was just to do what you were.
No, there were conversations, and they were aware of what the zoning ordinance was and things. I did not personally bring that up.
Well, who was present when those conversations went on?
Objection. Those are privileged conversations, Mr. Warner, between client and his experts, and I object to the question.
Who was present at those conversations?
Objection.
Well,
But,
goes to
Mr.
his
Berlin, there was an objection, and the basis for that objection is you believe he's seeking privileged information? Is that it?
Correct.
Okay.
I don't understand the relevance of it either.
Yeah. What's the relevance, Mr. Berlin?
The relevance is who is responsible for proposing these buildings that require approximately half of the parking, the removal of hundreds of trees.
Who set the size of the building? Is that what you're looking for?
I'm sorry?
Who set the size of the building? Who set the size of the building? Who proposed the size of the building? Is that what you're looking for?
Well, it's Signature Acquisitions, that's been testimony.
Oh, okay, so can we proceed?
No, but his question was, his answer was, there was discussion about the code.
Yes, but I do not know the specific, there were different people, different teams at different meetings. I was not present at that. I know it gets raised. Because when
Proceed, Mr.
the whole thing is with the development, it gets
I'm
put.
not going to ask him about any conversations with the attorney. I want to know who else besides the attorney. I don't know whether he was there or not.
Objection goes to relevance. I don't understand the question, why that matters at all. The decision was made by Signature to build the building. He gave instruction to, how many times do we have to say it? He gave instruction to the architect. He gave instruction to the civil engineer. What else do you want to know?
I want to know whether anybody stood up and said, you have to listen to the code.
Mr. Neighbor?
That's not a question
Yeah,
for this
yeah.
witness.
What's relevant is the burden of proof of the applicant. The applicant has the burden of proof to establish
That's
the
right.
positive, negative criteria for all the variance relief sought. It's not a matter of, and they're here because they're violating several code provisions, and that's why they're seeking variance relief from this board.
That's where I have a plan of it.
And there are engineers to answer the engineering questions, architects to answer the architectural questions, et cetera, et cetera. It may not be material, may not even be relevant whether anybody stood up or didn't stand up as to whether or not they're complying or not complying with the code. We know what the result is. They're not complying with the code. That's why we're all here. It's not an issue, this is not a criminal trial. This isn't a civil trial. This is a land use proceeding before a volunteer administrative body to weigh the criteria, positive and negative. The questions need to be directed towards those positive and negative criteria, not who took what notes or who stood up and said, I think we should abide by the code. We have the application, we have the deviation sought. I'm trying to help you to ask the right questions in the time. Everybody's going to have a time limitation eventually. You need to focus
Yeah.
on what's material and relevant to the land use application before this board. And I suspect I'm not just speaking on my own behalf, I'm speaking on behalf of the board and maybe even beyond the board.
Yeah, if I can just ask you, Mr. Berlin, we're trying to be as patient as possible, and we want to make sure that we hear your questions, and if you have any questions specifically for the architect that haven't been covered up to this point, we want to make sure they're heard. We are just past 9:30. Can I ask you, just for planning purposes, approximately how much more questioning you think you have, just so that we...
Quite a bit.
Quite a bit, okay. Then can we ask you to focus very specifically on questions that have not been covered to this point? If I can ask you to try to avoid restating testimony that he's already given, but questions that haven't been covered for the architect. That's what we're here for tonight. That's what we're trying our best to do. We want to hear your questions, but at the same time, there's a lot of other questions that need to be asked to other witnesses. We want to give the public an opportunity to ask as well. So it's really important that we focus the attention on questions that have not been covered for Mr. Neighbor.
Well, let me cut to the chase,
Thank you.
all right? If you were asked,
Is this a question for Mr. Neighbor?
yes, for
Okay.
Mr. Neighbor. If you were asked, sir, to construct, to design a light manufacturing facility on this 20-acre lot that did not violate the zoning code, is that something that you could do?
Yes.
All right. For instance, could you design a light manufacturing?
Mr. Berlin, I'm going to ask you, can we avoid examples?
I'm
He just
sorry.
answered yes to your question. So if you're going to ask questions with examples to prove what he's already said, I'll ask you to avoid that.
Yeah, you're right. I forgot
Thank you. No, that's okay.
the crime of
It's
not
not a crime,
staying on the microphone.
just a suggestion from a friendly volunteer board.
For instance, if you were asked to design a light manufacturing facility, let me go back. Have you heard the term footprint in relation to buildings?
Yes.
And what is a footprint?
It's the area the building sits on.
Okay. If you were asked to design a light manufacturing facility within the footprint of the present building, all right? Present office building, could you do that?
Not a viable building because that's a multi-story.
sorry?
It would not be based on the footprint of the existing building. It wouldn't lend itself to
Why
light
not?
manufacturing because the building's got angles in it. It's not square. It's multi-story, and it would not work as a light manufacturing building in that footprint.
All right, well, let's then talk about, assume that you were asked to build a building, two buildings, each 100,000 square feet, a total of 200 square feet, all right? Could you design that building? Both rectangular.
Madam Chair, you asked the question. You already brought the observation up. He's doing exactly
Yeah.
what I told him not to.
Mr. Berlin, I'm going to ask you to do, unless Mr. Warner tells me I'm not allowed to do this, I want to be as patient as possible. I want to make sure we hear all the questions, the same way we're giving the public as much opportunity to ask questions. But I feel like we're going to have to impose limits on time. If I can do that, Mr. Warner, and tell me if I can't. But I think there has to be a reasonable amount of time for a cross-examination of a witness, especially since he's already testified and there's been a lot of other cross-examinations. So at this point, it should really just be laser-focused on things that wasn't covered. I think that is, I think that's appropriate at this time. I know you said you have quite a bit. I'm going to ask you to try and finish in the next 15 minutes, which would be a total time of about 50 minutes. I'm going to ask you to try and do that, so be mindful of the questions that you ask here, please.
Did you say 15 or 15?
An additional 15
No,
minutes.
I cannot finish in 15 minutes. I can't do it.
Okay, so why don't you try? But can I establish a limit? Am I able to do that?
Certainly, anyone, council can weigh in if they wish to do so, but it's my opinion and advice that the reasonable time limits can be set forth for all cross-examination and questioning, not only members of the public, but also of council, and still establish one's rights, everyone's rights to due process under the state and federal constitution. So reasonable is the
It's
standard.
axiomatic under the land use law that, under the land use law, that the chairman has the discretion to impose reasonable time limits. We've already been going at this for 50 minutes.
I'm aware of the municipal land use law, and it's reasonable, and in my opinion, reasonable is also essentially the standard under the Constitution. Due process is required, and reasonable period of time for all parties to cross-examine, I think, adheres to due process.
The applicants have gone on this case.
Mr. Berlin, we're going to ask you for another 15 minutes. You can, if you have questions.
I cannot do it.
If you have
do you wish to
additional
try, Mr.
questions, or you
Berlin?
can be finished for tonight, it's up to
You
you.
want to cut me off, cut me off.
I
No one's
don't. I'm
cutting you
giving
off.
you an additional 15 minutes, which I think is a reasonable amount of time. It'll be almost 50 minutes of cross-examination. I think that is more than reasonable. So if you have additional questions at this time, you can continue with Mr. Neighbor.
I will continue for the 15 minutes, but I
Terrific.
tell you right now, I cannot finish in 15 minutes.
Okay,
Why don't-
that's, it's
Why don't you
that's not my
proceed, Mr.
concern.
Berlin?
Okay.
Why don't you
And I
proceed?
might point out that the applicants have now taken,
Mr. Berlin, everyone's aware of how much time everyone's taken. In fact, we keep track of the time, and every individual. Please use the best, most of your time.
Right.
We're trying to help you to cross-examine this witness appropriately,
do you
please.
remember my question?
We were in the middle of it with another scenario for designing a building.
Can you, my question was, if you were asked to design a building that is two buildings, each 100,000 square feet, a total of 200 square feet, could you design that building within the parameters of the zoning code?
Offhand, I don't know.
Pardon?
I do not know.
Okay.
I'd
that's fair
have to
enough. You
take
do
a look
not
at it
know.
and design, so. I mean,
Now, let me just, I'm trying to get through so I can
appreciate that, Mr.
cut
Berlin.
it down,
Please
so
proceed.
bear with me. Now, in designing the building, did you provide for loading docks?
Yes,
All right. And how many loading docks did you design? Asked and answered. Well, it's a preliminary question, for God's sake. 24 loading docks, correct?
Mr. Berlin, you can proceed.
Yes, it was up to 24 loading docks that we were proposing.
Do you remember testifying on June 7th that in your experience, only 25% of loading docks would be used?
I believe I said that in reference to warehouse uses. I don't believe I said that in relationship to the building that was designed. I think that was just a general statement.
You said that in relation to warehousing?
Into examples of where, yes.
Well, we'll check the.
Mr. Berlin, no commentary is necessary. You continue asking your questions.
Yeah, that's fine, if that's
Cross-examination.
what he said, but that is not
Thank you, Mr. Berlin.
my understanding of
Mr.
what he
Berlin?
said. All right? So you are of the opinion that 24 loading docks is appropriate?
Yes.
You testified to that, did you not?
Yes.
All right. Can you tell us, is there a portion of the code that provides for loading docks?
Yes, there is.
And-
There's a minimum number that's,
What is the minimum number?
it's based on the area of the building. Typically, I'd have to look into the zoning ordinance to see what the exact requirement of the township
You don't know
is.
the number?
Not offhand. I deal with a lot of different towns and a lot of different zoning ordinances. I do not recall.
Well, if I told you that for a building, for instance, of 200,000 square feet, it would be three loading docks for each of the 100,000 square feet.
I object. I don't know where this is coming from. Where are you citing from?
Yeah, are you citing a zoning ordinance or a different code, Mr. Berlin?
Well, I'm citing section 2139-2 of the loading requirements.
I'm sorry,
Number of
what ordinance?
off-street loading spaces to be provided in any zone. Each building or use required the receipt and distribution in vehicles or merchandise shall be provided with on-site, off-street loading spaces in accordance with the following ratios. And
Mr.
the
Berlin, I just asked
ratio
you,
is-
is that from the land use ordinance? The answer is
I'm sorry?
the land use ordinance. You're citing from the land use ordinance, correct?
Yes.
That's all I asked you. Thank you.
And that's a minimum.
Hang on, Mr. Berlin, hang on one second.
As opposed to loading docks. So loading spaces in land use.
No, I'm aware of the distinction. And, Mr. Berlin, you're citing the loading space ordinance of the land, of
Well-
Vernon Township Land Use Ordinance.
What,
To the extent he can answer that question, answer the
what's the
question.
difference between loading spaces and loading docks?
He's not the planner, Mr. Berlin.
No, again, in the ordinance is due for commercial buildings require a minimum amount of loading spaces regardless whether it's a B use or something based on area in order so that the building can be serviced. Again, an office building may not have the same frequency as a light manufacturing use or a warehouse use, but every commercial building does have a need for loading to bring products in, furniture in.
Let's talk about the lot of 28.3 acres. All right?
Okay?
Are you familiar with this lot?
Yes.
All right. Is the lot exceptionally narrow in any way?
The lot,
It has to do with the placement of his building.
Mr. Berlin, there are engineers and planners that address answers with respect to uniqueness of a lot. Again, in fairness, you're asking the architect questions that are generally asked of other experts in this area of law, zoning and land use law, Mr. Berlin, and also, this was not part of his direct testimony.
Well, let me rephrase my question. In placing the buildings that you designed on the property, did you consider whether or not there was any problem with the lot being exceptionally narrow?
No.
Did you consider any problem with the lot being exceptionally shallow?
No.
Except for the driveway leading in and out of the lot, is there is the lot exceptional in any way?
It's triangular, basically.
sorry?
The lot is triangular. We are not in a cornfield off the turnpike. It's not a square lot that's typical.
Did that cause any problem as far as the architect was concerned in placing these buildings on the lot?
No, because we were placing them within the confines of the existing ring road, and that was the directive.
Are there any exceptional topographical conditions on the lot that would prevent the construction of the light manufacturing facility on the lot at 200,000 square feet?
The property has a lot of elevation change, and that is one of the reasons it's two buildings instead of one, because we were dealing with contours, and there's a sort of a knoll in the middle of the property, and by pulling the buildings apart, the areas apart, we were able to develop it a little
Well,
bit.
you could have designed again, hypothetically,
Objection.
Commissioner?
This is a hypothetical, another hypothetical.
It's
asking questions of
Mr. Lair, hypotheticals are acceptable for an expert if they're relevant hypotheticals. Please proceed, Mr. Berlin.
would if there was any exceptional topographical conditions on the lot, would that have prevented you from building a 200,000 square feet, two buildings, each 100,000 square feet on the property?
I mean, there were challenges, but there was also opportunities, and that's why we put the parking underneath portion of the building using the topography that was there.
Sir, if you could build a building of 258,000 square feet on the building, on the lot, you could build one of 200,000 square feet, correct?
Sure. Yes.
Would that 200,000 square feet building require any variances?
Based on this site, in all likelihood, it probably would have.
What variances would it require?
I do not know. I'd have to design it and look at that and understand what.
So
Yeah.
am I correct in understanding what you just said? You don't know whether any variances would be required, correct?
Mr. Berlin, he said variances would be required, he just didn't know which
I
ones.
just want to be sure
So
we understand.
please, let's not
All
misparaphase anyone's testimony.
Okay.
Please proceed.
And Mr. Berlin, I know you want more time, but we're going to ask you to wrap up in 2 more minutes.
I can't do it in 2 minutes.
Okay, well, I will interrupt you then in 2 minutes. So if you have additional questions, you have
Can't do it.
additional 2 minutes.
I can't, next line of questioning would take more than 2 minutes. I can't do it.
Okay, so no additional questions right now?
I object the restriction. I want the record to be clear that I have been cut off. from-
Mr. Berlin, I think the record will be clear as to exactly what's occurred because the record is being transcribed verbatim.
Okay,
Thank you.
thank you very much.
Thank you. Okay, thank you, Mr. Berlin. At this time, I'm going to ask the public, in fairness, based upon any of the testimony we just heard from Mr. Neighbor and Mr. Berlin's questions, if you have questions based upon what you've heard tonight and only tonight, this is the time to ask. Yep, come on up. And just as a reminder, it's not a time for a comment, but if you have a question on what you heard tonight.
Just give us your
please
name and address.
And then please address it to Mr. Neighbor. So your
Right.
name and address for the record, please. Name and address?
Robert Saliba, 1122 Fellowship Road, Basking Ridge, New Jersey.
Thank you. Question for Mr. Neighbor?
Please let me know if I'm being relevant to this, because I'm not clear as to exactly what was brought out in the last hour or
He's
so.
the architect.
I understand that.
And you heard his testimony this evening, at least.
Mr. Neighbor, you were hired to do this project, is that correct?
Yes.
And the people who hired you were representatives or principals in Signature Acquisitions, is that correct?
They were it was Signature Acquisitions.
And you discussed,
We might need the mic near you. Or
Yeah.
you might need to share or take
Yes.
Mr. Berlin's mic.
Yes,
there.
it was Signature Acquisitions.
and did you discuss this with individuals other than Signature Acquisitions?
This project, it was discussed with the team, with the civil engineer and the other professionals that were part of the thing with Signature Acquisitions. Other than that, and my testimony here, it wasn't discussed with anyone else.
And Mr. Sylvia, I was just asked to just make sure, you're not, are you part of the entity that's represented by any of the other three attorneys?
Yes, I'm a member of Fellowship Village.
Right, but are you which attorney is?
I'm representing myself, me.
No. What the rules, we do have rules, actually.
Okay.
And one of the rules, just to be clear, that's why, the only reason we're asking.
Yeah.
Is that if any entity is represented by counsel, I think there's a board that Mr. Berlin represents?
Mr. Warner, he is an attorney.
It doesn't, what I'm asking you, not if he's an attorney, that's not what the rule says. Is he on the board that you represent? Who's your client, Mr. Berlin?
He's a resident of Fellowship.
No, who's your client?
My client is the Fellowship Resident Council.
Council, is he a member of the council?
I am. In fact, I'm president of the council. Now, maybe
Right.
I should not be here.
No, you could be here, absolutely you should be here, in my opinion.
I should not be asking questions.
Asking questions, correct, that's what the rule says. If
Okay.
you're represented, if you are the client that is
Yep.
represented by the attorney, our rules prohibit the clients from asking questions, because that's why the attorney's here, to do the cross-examination. You absolutely have the right to make public comment. That's the rules. That's why I asked. I didn't realize, we don't memorize who the board is. So in fact, we have to rely on Mr. Berlin to let us know if this is his client, because he knows the rules.
Well, even if Mr. Berlin gave me permission to ask questions, would that still be the case?
No, he's, you can't even be his co-counsel.
That's my job.
Yeah, unfortunately. But that's one rule we don't have any exception to. I'm sorry,
Mr.
but the
Warner,
board
excuse
can't.
me, he's not my client. The council is my client. He happens to be
You just said he was on the, he just said he was on the council.
Yes, I'm on the council.
Yeah, so that he is the council's your client, yeah.
And he's also an attorney.
I understand, that's not under the rules. The rules are that only you could cross-examine witnesses on behalf of your client can't also. It's just the rules of the MLUL. Any of the objectors' counsel or applicants' counsel can tell me I'm wrong if they believe me to be wrong.
So you're telling us that no resident of Fellowship Village
No, I'm
can
telling
ask
you
a
that the
question.
municipal land use law, as I understand it, would preclude you from, would preclude your clients from asking questions in addition to you asking questions.
All right.
Just like Mr. Simon has clients, Ms. Smith has clients, same thing. And we rely, frankly, to the extent we need to, on them to let us know if one of their clients are asking a question, because they would regulate that.
Is that,
Okay, so my apologies, but
No, I'm the one who's apologizing because I
That's
didn't know.
okay, well, we accept
Yeah.
it, thank you. Let's accept each other's apology for the
There you go.
municipal land use law.
All right, I'll just sit down and shut
We
up.
should move on
No,
to the next
and-
member of the
and-
public.
And just so that you heard Mr. Warner,
Yeah.
you're not precluded from making a comment when we're all finished with this
Exactly.
trial. That's different. So when we get to all the testimony is finished and we ask the public if they have any comments for or against that application, you are able to make a comment at that time.
At that time, I will.
Yes, thank
Again, I apologize.
Thank you. No, that's fine. Okay.
So let me just.
Any members of the
Are there
public who are
any-
not represented by counsel?
Yeah, that's my fault. I should have said it that way. But if there are any members of the public who are not represented by counsel here who have questions for Mr. Neighbor, this is the time, please. Yes, please come up. We're going to ask you for your name and address for the record, please, and speak into the microphone. And again, it's questions based upon what you heard tonight for the architect.
Thank you. My name is Krishna Nalan, 194 Patriot Hill Drive, Basking Ridge.
Patriot Hill?
Yeah.
Thank you.
So my question is to start with the comment that we started this meeting with, that there was a confusion between warehouse versus a light manufacturing. So my question to you is, when you start designing this building, what kind of information would you need to design? Would you need to know what kind of manufacturing will be done? And then if there is a change in who the tenant is, and I'm assuming that you don't know the tenant yet, right? And if there's a change in the tenant, will there be changes in the architecture of the building? And then would you think that that will need some more variances to be requested for?
Okay. With the building, the design was to be, since we did not know the tenant, there's flexibility that needs to be designed into it. That is why we had the quantity of loading docks, the height and area of the building, and the layout in order to accommodate either a single tenant in a building or possibly multiple tenants in the building. So there would not, in my opinion, there would not be additional changes needed to the building based on fitting different light manufacturing uses into the building.
So are you saying that the building is designed to house a maximum capacity that it can be used for, irrespective of who the tenant is? Because if you say that, you plan for 24 loading docks so that...
We need to keep it to the question, not an explanation of the question.
Okay.
If he can answer the question, if he needs an explanation, he'll let you know. So did you ask your question?
So my question was, like, were these buildings designed keeping in mind that this is the maximum that you can use, even if the tenant wouldn't need that much space?
Again, the elements of the building were designed, again, up to 12 loading docks for each of the buildings to allow for flexibility. It was not, do not see it going, again, it's not going beyond that. It was designed, we put the maximum number that we thought we would need, and that was part of the design decision in terms of the layout.
Did that answer your question? Yes. Okay. Thank you very much. Any additional questions from the public for Mr. Neighbor? Okay, seeing none, thanks for coming back again, Mr. Neighbor. Mr. Lair?
Madam Chair, it's 10 o'clock.
It is.
And I don't think it would be useful or wise to start the cross-examination of Mr. Travellini. I think that it would only be because of the timing. So I'm going to ask the board what they think. If you want to go till 11 and start cross-examination, I'm fine with that, but I'm not so sure how productive it would be.
I agree with counsel.
Well,
I didn't ask what you were
That's okay, Mr. Berlin. Well,
doing. Even interrupt that.
All right, hang on.
Although I'm sure for the record, it's, and it's appreciated by everybody. But the chair will decide and the board will decide how much longer they're going to go. But I believe we're up to Mr. Travellini's cross-examination, still to be done by 3 objectors' attorneys and members of the public who are not clients of those objectors' attorneys. So it's for the chair and the board to decide.
Okay, so just as a reminder, where we are is now bringing back Mr. Travellini, and we did not get cross-examination by any of the objectors.
That's correct. Right, he
Okay.
testified on direct on hearing 4, August 9th.
Thank you. Can I ask the objectors' attorneys approximately how much time you think, if you have a guess on how long you think the cross-examination would take?
Can I turn that question around a little bit?
No.
How much time will you allow?
I just want to get a sense of time. If you have a guess at the time, I'd just like to know for planning purposes. It will inform the board.
Yeah, maybe Mr. Simon can help here.
Be extensive.
Mr. Berlin, we're going to hear from Mr. Simon. Thank you.
Thanks. In terms of timing, sensitive to, the board's volunteerism, I would have probably more than an hour, certainly, of direct.
Thank you. Ms. Smith, maybe, with the chair's permission?
Yes, please. I'm here.
So I believe when it comes to Mr. Travellini, I will actually be going third if we keep the order we established.
Mhm.
I think I have about 45 minutes. It may be less if the questions that I intend to ask have already been asked.
Understood and appreciated.
Okay. And then, obviously, we have the public as well.
Right.
Okay. What we're going to do, and I agree, I don't think it makes sense to start the objecting cross-examination. There's a lot of members of the public here. I don't know if the public has any leftover questions that they can recall from the last hearing that they want to ask Mr. Travellini tonight. He's here tonight. If you have questions that have been burning in your mind for the last 6 weeks that you would like to ask tonight, because ultimately we are going to carry this hearing. It will be another month out. We will hear additional cross-examination of Mr. Travellini at that time, and you can have an opportunity to ask your questions then. But just out of respect for everyone who's been here tonight, if you have a burning question that you want to ask right now before we carry the hearing.
As long as they're not represented by counsel.
Thank you, Mr. Lair. As long as they are not represented by counsel. Is there any questions that are important to ask tonight to Mr. Travellini?
Who testified last time.
That's right. Okay. People from the public will have an opportunity at the next meeting to ask questions at that time. I just wanted to give that quick window now. I think given the time, a little after 10 o'clock, just from a cadence standpoint, it doesn't make sense to start that cross-examination tonight. So we are going to carry this hearing, Cindy, to Ms. Kiefer?
I believe it is October 12th.
October 12th.
October 12th.
It is October 12th.
So this matter, with the chair's permission, will be carried without further notice to October 12th, right here, the same venue, at 7:30 PM, with an extension of time to act. Well, we have one already through the end of the month of October, so that we're good for now, unless Mr. Lair wants to extend it further.
Just one question. Will that night be devoted entirely to the signature
W-
application?
As of right now, it's devoted. Sometimes things come up and we have special circumstances. It's been very difficult, as you can imagine, for the board this year. It's been a tremendous amount of time, and we have other members of residents here in town who have other applications to do. So we're really doing our best to fit everybody in and not go into, the next day for these meetings. So as of right now, and our plan and our hope would be to allow the entire meeting for signature. That is our plan. And as a reminder, that's a special meeting that we're already volunteering for. Just so the public knows, there is another zoning board meeting that's on October 4th. This case will not be heard in any way, shape, or form on the October 4th meeting. You're welcome to attend that meeting, but if you're here to hear signature, it's October 12th.
Can I ask one last question, and then I'll end it? Is there any other night that you can devote in October, November, exclusively to the signature application?
Above and beyond the special meeting you're asking.
Correct.
Why don't you leave that question with the board, and maybe we can circle back with you.
Okay.
And obviously, if that is decided, we will make sure everyone is aware, the public is aware as well.
Thank you.
Thank you.
Madam Chair, I'm sorry I'm interrupting. I would just ask that if there is going to be some offline discussion about special meetings, that council at least be consulted, because I know a very busy schedule,
Yes.
including, I actually already have a hearing
sure.
on October 12th, which is going to cause a problem for me, but I'm keeping my mouth shut, and I will make every effort to be
Yeah,
here.
that's very fair. Of course, we're going to make sure that it's relevant for,
Thank you.
thank you.
So, just so I'm clear, October 12th, we will proceed with the cross-examination
Of Mr. Travellini.
if by any chance there's time left, who will be the next witness?
I think they said, was it traffic?
Traffic, I think.
That hasn't changed,
Yeah.
correct?
That is not.
Okay.
I appreciate that question. It leaves me very optimistic. Very good. Very good. Okay. Thank you very much. If I could remind everyone, this board meeting continues. So if you're leaving now, if you can do that quietly and without conversations, so that we can wrap up here. Thank you very much. Okay. Are there comments from members? I have one comment. Ms. Kiefer, I received an application in the mail today. Is it different than something, I believe I already had it, the application I received in the mail. I was wondering if it's new or different for any reason?
I would have to go back and look because that was mailed quite a
I
while ago.
believe it was for the December meeting of Rogers. I believe that's what I received in the mail today. But I believe I already had it. Oh, is it a new one?
Yeah, it was additional, some materials need to be
Oh, it was
replaced.
incomplete, and this is the complete. Thank you. It's getting difficult. My dining room table is now covered with applications, and I'm trying to keep it.
I will be sending out another application to the board, probably early next week, for an application that is now.
Sorry,
scheduled to
members
be
of the
heard.
public, it's very difficult for us to hear. If I could ask you to exit if you're leaving. Ms. Kiefer, sorry, I didn't hear you.
I will be sending out another application to the board that will now currently be heard on October 4th. As I said, we've had a significant change in our schedule of hearings. I've not ever seen it like this. So we've had a
Is that
change.
already on our pending applications list?
Yes, it should be there in red. It would be the Brinkworth.
Brinkworth, okay, so that one's coming in the mail, we don't have that.
Right.
I do believe we have the other three.
Right.
Okay. Okay. Any other comments from members? Comments from staff? Oh, yes, you will.
I mean, I'll be in Phoenix. I might be two-dimensional, but I
Okay,
will not be here. I'll
thank
be out
you.
of the area. so.
Okay, thank you, Mr.
And
Quinn.
it sounds like I might not be missing a whole lot.
You never know.
True.
I don't know, I heard some optimism today.
I was gonna say, that
Um,
depends if they get the traffic or not.
engineer
Yeah.
Yes.
Is there anyone else who should stay in your place, or do you just
I
watch
could
the
send my
meeting?
wife, but she's not an engineer. I don't know.
She's
if
more
she
than
would
welcome
need
to
any
come,
help.
as long as
When
she's
she
not
finds out
represented
what I
by
actually
counsel, she
do.
can ask questions. All good. Okay, thank you, Mr.
Madam
Quinn.
Chair, if you really want an engineer here, I can see if I can get a civil engineer from my firm to cover.
No,
but-
just,
You're a traffic engineer,
He's
right?
also, yeah, he's-
Yes.
I find you to be very civil.
Ha,
You'll
ha,
probably do.
ha.
I saw that one coming.
You'll probably do, but that's a nice offer, so.
I mean,
Any other
I'm not gonna be needing so.
comments from staff? Motion to adjourn.
Motion.
Second? All in favor?
Aye.